The Albanese government plans to introduce legislation tomorrow to amend the Environment Protection and Biodiversity Conservation Act to ensure the future of salmon farming in Macquarie Harbour on Tasmania's west coast. It's unclear exactly what those changes are, but the federal opposition has indicated it will support the bill through the Senate. Professor of Environmental Law at the University of Tasmania and Biodiversity Council member Jan McDonald joins us now from Hobart. Jan McDonald, welcome. So a spokesperson for the PM has described the Environment Act as flawed and needs amending to secure jobs and local industry. Do you agree that the Act is flawed?
The flaw that the Prime Minister has identified is a power that the Environment Minister has to review decisions made earlier that the Commonwealth doesn't need to get involved in an activity or the regulation of an activity in circumstances where new evidence has come to light. So this was a decision back in 2012 of the Environment Minister of the time that the expansion of salmon aquaculture in Macquarie Harbour didn't require an approval from the Commonwealth, provided it was undertaken in what's referred to in the Act as a particular manner. And because the Commonwealth said we don't need to give approval, the Act has provided this safeguard for the Environment Minister to go back and say, well, actually, the evidence suggests that there is a problem, that there is an endangered species that's being very significantly affected. Maybe we do need to go through an approvals process. So I guess whether or not you think that's a flaw in the legislation or whether you think that's a critical safeguard that allows for adaptive management depends on where you stand on Australia's compliance with its international biodiversity obligations.
And where do you stand?
Australia's committed to no new extinctions. We've committed to safeguarding biodiversity, and our obligations are clear in international law terms. So in circumstances where the Commonwealth has said, we don't need to grant an approval yet, or at the moment, because we don't think there's going to be a significant impact. But experience tells us that, in fact, there is a significant adverse impact. My view is that at the very least, we should be keeping that option in the legislation. And the reform that's being proposed to go through tomorrow on budget day with no opportunity for public consultation is one that would remove the power of the Environment Minister ever to go back and look at those so-called particular manner determinations.
And so what's broadly at stake here if this Act is altered?
I suppose there's two answers to that question. One is the fate of the Maugean skate, which is the particular species that is being most adversely affected by operations on Macquarie Harbour. Now, recent evidence suggests that the skate is responding well to some of the interventions that have been implemented under the conservation advice, but it's by no means out of the woods. And to completely remove retrospectively the power of the minister to review that earlier decision does raise really difficult questions for whether or not we've got enough to protect the Maugean skate. More broadly, though, there's a much bigger question about the way in which this reform is being introduced. It was the legislation, or the draft bill, was only seen for the first time this afternoon. It's being tabled tomorrow with voting tomorrow evening during the budget. It's being scheduled for Senate consideration on Wednesday. And this is really in stark contrast to the literally years of consultation on the reforms to the Environment Protection and Biodiversity Conservation Act that this government committed to when it took office, the nature positive reforms. Now, it worked hard on those, gave up on them at the end of last year, But that was the kind of consultation that was needed. And instead, what we're going to end up with is the only reform to this legislation being a dilution of its protections rather than a much needed enhancement of them.
So if this change goes ahead, and it looks like it will, how do you think it reflects on the government's environmental commitment?
I think it raises really interesting questions about how they're going to proceed. We haven't seen any progress on the desperately needed improvements to this national safety net, the green safety net that is our national environmental law. The review of that act back in 2020 recommended a whole raft of improvements. The government had committed to them, and none of them have been delivered. And that's a real concern. Australia's biodiversity is almost across the board in a worse state than it's ever been. And strong environmental laws are a critical, not the only, but a really critical part of ensuring that we not just stem the decline, but reverse it.
And so could this change be legally challenged in any way?
That's a really interesting question. I think that it's going to be very difficult to challenge it. It's interesting in that it's going to operate retrospectively, which is quite unusual in law reform. It's going to operate so that the decision that's currently being reviewed or considered for review by the Environment Minister is taken off the table completely. But if this gets bipartisan support, it's going to be, I'm not going to say it's impossible, but I think it will be very difficult to challenge it in any kind of legal sense. Interestingly, this bill is expressed in quite similar terms to a proposed reform that was put forward by the Coalition last year, which the Senate Environment Committee, chaired by a member of the government, rejected and recommended against adopting last year. So it's not a completely new model in that we've seen provisions of this sort before. I think perhaps one of the most problematic things is that what we're seeing is the removal of a protection that applies across the board in our national environmental law simply to protect one activity in one location. And I think it would have been preferable to see the government develop some other innovative legal solution to that problem rather than to further undermine and further weaken the environmental laws that we've already acknowledged need improvement.
Okay, Jan McDonald, thanks for talking to us from Hobart.